Iku Iluna, please rise. Auhea o ko e ko ka aha, inahe kuliana imua o kia aha ho o kolo kolo ki eke e hanahano o ka moku aina o Hawaii. E naoi mai, e molio mai, I lohi ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilal, please be seated.
Nelina, makamoku puni o Oahu I ka moku o kona e ano ka koma a Leolani Hale. Greetings. On the island of Oahu in the district of Kona, we are gathered here at Ali'i Olani Hale. Please call the case.
Case number SCAP-24-0000461. State of Hawaii Plaintiff Appellee versus Joshua Nahulu, Eric Smith, Jake Ryan Bartolome, and Robert Gus Lewis III, defendants appellants. Arguing for defendant appellant Joshua Nahulu, Richard Singh. Arguing for defendant appellant Eric Smith, Doris Lum. Appearing for defendant appellant Jake Ryan Bartolome, Pedrick Arisgado. Appearing for defendant appellant Robert Gus Lewis III, Benjamin Ignacio. Arguing for plaintiff appellee State of Hawaii, Deputy Prosecuting Attorney Brian Vincent. Argument on the merits.
Aloha kakahiaka and good morning. Today's proceeding is being broadcast live on the Judiciary's YouTube channel and on Olelo. And I'd like to welcome our substitute justices in this case, Judges Lisa Cataldo and Brian Costa from the First Circuit. Counsel, are you ready to proceed? Yes. All right. The court has allowed 30 minutes for each side. And to confirm, Mr. Singh, I understand you intend to argue for 15 minutes. Ms. Lum, you will have 10 minutes. And Mr. Singh has reserved 5 minutes for rebuttal. And Mr. Vincent, you will have 30 minutes with a 5-minute warning. Mr. Singh, please proceed.
Good morning and aloha. I represent defendant appellant Nahulu in this matter. We come before this court attempting to raise the same problem in two different contexts. The first is that the people of Hawaii don't have a clear and understandable rule that tells them when they must stop and render information and aid to fellow motorists. And the second is that the charging document in this case is insufficient because it does not define a vague and ambiguous term, the term or phrase involved in a collision. So those are our goals. That's what we intend to raise here. The problem that rears its head as we see it is the terminology in 291C12 involved in a collision. It is fundamentally unclear and motorists cannot determine what their obligations are when a serious auto accident occurs near them. This lack of clarity leads to the danger of arbitrary and discriminatory enforcement. So let me start with the constitutional problem. We raise the issue of vagueness here, and the test is relatively clear and long-standing. Can an ordinary person determine what conduct is prohibited? Now, the first point I'd like to make here is that test, that specific test, seems insufficient for omission-based offenses. We're not talking about an ordinary person trying to identify what conduct is prohibited, but we are trying to determine when someone must act. Commission-based offenses are things like you can't steal and you can't assault. And those are fairly clear. We know where the line is. We know how far we can go up to it. Omission-based offenses are not like that. And maybe the test should be slightly different. There's really two parts as I see it. The first is a person must try to determine when they must act. And then secondly, what actions must be taken. The second part is the easy one. That's the one that's laid out clearly in the statute. You have to give up information and you have to render aid. It's that first part that's difficult. And really that's the fundamental point I hope to make here, is that when you must act or suffer criminal liability, in this case, 10 years of prison, it needs a clear trigger. It needs a clear way for motorists to determine when they have to give up information, when they have to render aid.
Mr. Singh,
yes.
you're asserting to us that maybe the test for determining whether someone must act, an ordinary person should act, perhaps that test should be adjusted when there's an omission involved. What about where a police officer is involved? Should the test account for that as opposed to an ordinary person?
No, so especially in this case, we come before you as an interlocutory appeal. There's been no facts established, and I would respectfully submit that police officers, like every other member of our community, should be treated in the same manner. And the trigger for which they must act should be the same for all motorists, regardless of whether or not you wear a badge.
So because we're interlocutory and there hasn't been a trial yet, we're not to assume that they acted in the scope of being an officer at the time?
Well, I think the two challenges we bring here today, one is a facial challenge to the statute. I'm simply saying that the statute as currently written is unclear. It doesn't provide that trigger. And the specific facts of the case aren't necessarily relevant to that evaluation. And then part two to that is the charging document, and we're evaluating the charging document itself for sufficiency and notice.
Okay, so in terms of your facial challenge, what is the constitutional implications that are in this case, that are implicated in this case, that raise it to a facial challenge?
So
What are the constitutional rights for which that allow a facial challenge here as opposed to an applied challenge?
So the facial challenge in this point, I believe that that's the proper, because what we're claiming is not as applied in a specific case or under a specific set of facts. Our claim here today is that the statute as written doesn't give proper notice to motorists as to exactly when their duties are triggered.
But under an applied challenge, don't you have to show that somehow the statute as written is going to infringe on significant constitutional rights? What are the constitutional rights involved here, as opposed to in an applied circumstance?
So I think we're talking about pure due process. I believe the Hawaii Constitution, I laid it out in the brief when I had this, but I think it's Article 1, Section 5, due process. I might have the exact ones wrong, but it's a straight due process argument.
Okay.
Yes.
Are you suggesting that if a driver, an ordinary person would not know that based on this statute, if they run a red light and they crash into and, severely, airbags go off, clearly someone might be seriously injured, they don't have a duty to stop at that point? That they would not know that they have a duty, that they were involved in a collision under those circumstances?
So absolutely not. If the driver vehicle, the defendant vehicle, is in a collision, I think that's the simplest possible factual scenario.
So in actuality, you are making an as applied challenge, because in most cases in which this statute is applied, it's going to be the clear collision, right?
So I think in most cases, that's true. The problem, as I see it, is in the outer limits of where involved in a collision lay.
Right, so you are making as applied challenge where the evidence or the charge says, based on the bill of particulars, there was no physical contact between the vehicles.
So absolutely not. I don't think that's not what I'm trying to do here today. What I'm suggesting is that a driver cannot determine when they're required to fulfill the obligations of 291 or 291C12 when, based on really any factual circumstance they face, because it's easy to determine when there's an actual collision. The problem is the term itself, and it seems based on the 1971 amendment of this statute, it's intended to go beyond mere collision. The problem is the language of the statute doesn't do that clearly. That's how I see it. So I don't see this as an as-applied challenge. I see this as a direct challenge to the statute because the term is not defined in the statute.
So it is your argument today that if you were representing a client that ran a red light and crashed into and just totaled a vehicle that had the right of way, clearly someone is severely injured in that vehicle, you would be arguing that you would be able to challenge 291C12 subsection A.
If the question is, could I challenge, then the answer is yes. If it's, should I challenge under those circumstances, the answer is probably no. But I think the answer is yes as to whether or not I could. And that's because—
Of course you'd have the right to challenge it. Of course you would have the right to challenge anything.
Yeah.
But do you think it would be a valid challenge?
So yes, because the same issue exists. Now, as applied under those circumstances, I would probably never raise that issue. But when you're trying to determine what your obligations are, and that term is simply not defined in the statute, then I think absolutely, yes, it's challengeable.
You know, I'm wondering, you know, you're saying there's no as-applied challenge here, but, you know, your briefing talks about there not being a collision. That seems to be suggesting there's factual pieces of information there. But going back to the facial challenge, this isn't a First Amendment case, you know, so it seems to me that you can really only do an as-applied challenge, which you're saying you're not doing. But let's say, for example, that you were doing an as-applied challenge. I mean, wouldn't we then be considering the scenario in this case, which, you know, as alleged, you have a police officer in hot pursuit, and moments before a crash, you know, Honda, in this particular case, the Honda crashes after this hot pursuit. I mean, isn't that officer's understanding within the common understanding of what it means to be involved in a collision?
So I think I'd like to answer the question in two parts. And the first part is we are an interlocutory appeal here. So there's been really no facts established. So I guess we look to the charging instrument then and see what the specific accusation is. And in that case, with the Bill of Particulars, which frankly is, I believe is insufficient because it does not describe conduct, it describes what they're not doing. But I think if it was as applied in that fashion, that you would look to the charging instrument and look to the accusations made, which is simply tracks the language of 291C12.
Well, but isn't count 5 a conspiracy count, which does throw some overt acts into the factual mix?
Perhaps the conspiracy charge does bring that up. My client is charged with 291C or 291C12.
I mean, isn't the common understanding of involved pretty broad?
I think it is pretty broad, and it's probably intended to be pretty broad. The problem is, as really I see it, is where is that outer limit? And I think you have to think about the distinction between someone who's merely present based on proximity. You're 10 feet away from a serious crash, versus someone whose conduct contributed maybe substantially. And I think there's two ideas there. First is the idea is that we don't really attach criminal liability to people who are simply present. It's usually based on conduct. And so I think that's the first idea that we got to try to think about when we talk about where's the outer limit, is simply being near an accident enough. And then the second part to that is sort of looking at the conduct, because you ask yourself, if a person who engaged in no reckless, negligent conduct, but who was 10 feet away from a serious accident, is there a legal obligation to stop under that circumstance? And it illustrates, I hope, the lack of clarity in the existing statute and the need for a specific definition in the statute.
Well, pre-1971, this statute required an actual striking of or an actual collision by the person who's being charged, right?
Yes.
With another person or another vehicle. 71, they went to involved in an accident. And in 2021, now we are with involved in a collision. Okay, so involved in has been around since 1971, and in Chen, the Chen ICA decision, former Justice Akobo, when he was sitting on the ICA, defined involved as affected or implicated. How is that not, and he based that on, or the ICA based that on a dictionary, normal, ordinary reading of the word involved. How does that, a common understanding not jive with that?
So I would respectfully submit that affected and implicated does not add much to the analysis here for a motorist on the road trying to determine whether or not they have to stop at that point. The statutory definition, I mean, I think the first thing to look at there is that's a case law definition that depends on reading the case law, which goes back to a uniform vehicle code. A person of normal understanding isn't going to be able to go through that kind of analysis. And so, I mean, I think that's the first point. But I think almost the more important point there is that terms like involved, affected, implicated, they're not really bright lines. They're probably better viewed as a scale, a gray scale, where there are different levels of being implicated, there's different levels of being involved, and there's no measurement tool in the statute. Any time, any relation, or substantially related. We don't have any kind of direction as to how much, not necessarily the quality, but the quantity of it.
But maybe that's what the legislature intended, because the whole idea is to require individuals, drivers, to stop, render aid, and to provide information. You know, I mean, so it's not like there's the whole idea is anyone who is involved, however you want to define that, will stop for those purposes. So it's intended to be broad, isn't it?
So I think it's absolutely intended to be broad. The problem is there's no definition, and the definitions we don't have a measuring device within that gray scale.
What's your suggestion then, real quick? I know you're...
My suggestion, I got kind of a complicated suggestion. Would you like me to do it now or on my last 5 minutes?
We might as well do it now, and then we can
Okay.
adjust your time if necessary.
So I think there's a couple of things to think about what should be there. First, I think you need an adverb of some kind. You need marginally, substantially. You need something that defines how much you have to be involved. Or else we're stuck at mere presence. We're stuck at proximity. And I would suggest that those are not the ways that this should be looked at. Unless the legislature want to say, if you're within 50 feet, you got to stop. Then we know. Then we're sure. But for someone who hasn't engaged in improper driving, bad conduct, then that person is left trying to figure it out. Mm-hmm. And really that's the point I wanted to make. So I think there needs to be an adverb that defines and narrows that gray scale. And I think we can't go as far in that definition as to creating criminal liability for someone who's merely a witness. Because when we give up information, when we are forced to interact with the police, those are all constitutionally defined things as well. So I hope that answers your question. I know I don't have a specific definition to give you,
Thank you.
but that's how I'd look at it.
Thank you.
All right.
Thank you.
We'll go ahead and hear from Ms. Lum now.
Good morning, Chief Justice, Associate Justices. My name is Doris Lum. I represent Eric Smith. Thank you for accepting transfer of this issue, which is not only important to our clients, but really to all of Hawaii's citizens and guests, because as everyone in this room can agree, every person has a right to not only know, but to understand what the laws are. What we are here for today is not to address some obscure criminal statute. We're talking about clarifying a statute, again, not just for our clients, but for literally everyone who drives a car in Hawaii. They need a clear understanding of what their duty is. So the statute must be clear, unambiguous, and easy for everyone to understand.
Pardon me, Ms. Lim, but I'm wondering why you're even here. Let's say we agree with the 291C12 arguments by Mr. Singh. You know, the hindering prosecution offense really goes to the integrity of the justice system, and it's completed upon the defendant's conduct and the intent to assist. So its outcome, whether it's prosecuted or not, really doesn't control. So how does any definition of involved in a collision relate to the sufficiency of your client's hindering prosecution charge? And the same thing goes to Mr. Bartolome, Mr. Lewis.
The way that Mr. Smith and the other defendants are charged with that, the hindering prosecution, is that the charge that Mr. Nahulu is charged with is part and parcel of that. So there are other statutes that are hindering prosecution, which makes it a misdemeanor. We are facing a felony because Mr. Nahulu is charged with.
I'm aware of that, but isn't hindering prosecution doesn't really even matter what the actual charge was?
I would respectfully
So if 291C12 is out of there, do you contend that collapses your case?
It does not, because again, Mr. Smith, my client, is charged with a felony solely based off of 291C12.
And by the way, I look at your brief and the briefs of your co-defendants. Your brief is identical to Bartolome's brief. Lewis's is, a couple little tweaks here and there. I mean, it seemed like a lot of wasted time for us to read 3 of these briefs, which were identical. Do you have any response to that?
I'll make very clear that brief was mine. The issues shared with the other 2 defendants are obviously similar. We're in the same boat, and so they've preserved their issues as.
Yeah, I would suggest later perhaps trying to consolidate them so that we don't waste time reading superfluous briefs. But anyway, continue.
Understood. What I'd like to take time now to talk about is really the amendment to the statute. I think there was a previous question in regards to what the legislative intent was and the change in 2021 from the term involved in an accident to involved in a collision. This change is significant. It is changing something that is broader, subjective, I would call it, to something that is objective, meaning collision. There is no other way to define or understand what collision means. It means contact. And so the change in this statute in 2021 is very important to this court's analysis. The state in its briefing had a footnote in which it listed a number of cases that the court, that was asking the court to view. I would argue that these cases are not relevant or don't provide guidance to this issue because in those cases, as you will note, the phrase that was discussed was involved in an accident, same like in Chen. And here we have, again, the statute changed to involved in a collision. With the state's claim that there is one case out there in the Florida Supreme Court that supports our position, that's a little bit inaccurate. And I will turn to Gauden at this time. Gauden is the only case that's analogous to what we're talking about, because in Gauden, it discussed the phrase involved in a crash. It didn't use involved in an accident. It is factually similar to what we have here, which is
But that case involves crash, not collision, right?
correct. And I think we have factually more of a similarity with crash and collision than we do with, again, accident and collision. So I would argue that crash is analogous to collision. You know, in that case, the analysis, again, stressed the change in the wording of the statute, and they used that to come up with its ultimate holding that there does need to be a crash with the defendant's car. It was not enough in Gauden that the passenger in that vehicle that the defendant drove was ejected and then crashed into the ground, right? So the court made very clear, as I think this court should as well, that the collision or the impact here needs to be the starting point, as Mr. Singh had previously discussed.
You would agree, however, that Gauden is basically an outlier when it comes to cases construing the Uniform Vehicle Code and involved in an accident or involved in a collision. There's a lot of cases that deal with like drag racing, things of that nature, that say that, you know, even though if you're drag racing and the other car is involved in a collision, not with your vehicle, but crashes, you do have a duty to stop and render aid.
As I stated earlier, in the cases that the state cited in their footnote, that dealt with the phrase involved in an accident. And if we could address the drag racing, because I think it's a gut check, right? When you have two racers and then there's no contact and racer number two veers off and collides and has an injury. It is hard for us to say, well, the driver has no duty. We can all agree that that driver, that defendant driver, should stop because they're
So
part
how
of the
does that
cause.
differ from this situation?
Because here the statute reads not only involved in a collision. If you take the statute, it starts with the driver of any vehicle. It's specifically, when read together with involved in a collision, it's the driver of any vehicle. It's the collision with the driver, the defendant's car. That's the jumping off, that's the starting point. As Mr. Singh
Are you
indicated,
suggesting the cases from the other jurisdictions did not also have the language the driver of?
I'm suggesting in the cases mentioned earlier that it is not persuasive because of the ending of that which is involved in an accident. Much like Chen, Gauden is, I would argue, not an outlier because its reading is statutorily analogous to what we have here today. But going back to the hypothetical where the racing, right? We can all agree they should stop. They caused the accident. And even if they didn't cause the accident, they should stop. But what we're discussing here is not an argument on morals. What we're talking about is statutorily what is required. We're talking about a criminal liability and what triggers that. And as the statute is written now, it is ambiguous. What we do know, and what I would argue, is that, again, it has the starting
You would
point.
agree it's not ambiguous if the vehicle does crash, the factual scenario, the hypo that I raised, that it's not ambiguous in those circumstances, is it?
I would still argue that the statute is ambiguous because what is the involved in?
When you drive and you run a red light and you at a high rate of speed and you crash into a car with a right-of-way and airbags go off, total the other car, it's ambiguous whether you were involved in a collision?
I think the simplest example which you gave, two cars colliding, that is less ambiguous, yes. But where the ambiguity lies is, again, those outer limits.
So we are talking about an as applied to these circumstances challenge.
It is our position that it is on its face vague because we don't know what those outer limits are. We don't know what the definitions are. And I do understand.
Sounds like a textbook as applied challenge.
Respectfully, I will take that note. I am.
You're out of time. Please wrap up.
Okay. Thank you.
Thank you. All right, Mr. Vincent.
Good morning.
Thank you.
Sorry, I was confused. I thought more than one would do. Okay, so it seems that at least one of the defendants is arguing statutory interpretation here. So I'm just going to go through briefly 6 reasons why we think that it should be interpreted as we suggested in our brief. The first reason is that the drafters of the Uniform Vehicle Code commented that the code requires such stops by any driver involved in an accident, even though there is no collision or striking of another vehicle or person. So the drafters spent time thinking about all the different vehicle infractions that could, and they came up with a considered idea about who should be responsible for staying at the scene and leaving information. Second, the predecessor statute, HRS 291-2 requires stops by drivers only when their vehicle strikes any person or collides with a second vehicle containing a person. So that one clearly involved a physical contact between the defendant's vehicle and and some other vehicle or object. Okay. Even if the legislator was not aware of the commentary by the drafters of the Uniform Vehicle Code, the legislature surely would have been aware of the difference between the new statute that they are enacting and the old statute. A third, and this is related to the second one, is that generally one of the statutes or one of the canons of statutory construction is that a statute should not be read in a way as to render words or phrases superfluous. And I guess what the defendant's arguing would render involved in superfluous. So it's another indication that it has a much broader impact than just being physically involved in a collision. Fourth, we have a persuasive published 30-year-old opinion, Chen, okay, which is remarkably similar, except in, we think, a kind of non-substantial way. And that was where Jin was struck by a taxi. The taxi went off into the sidewalk and killed a pedestrian. Okay. The issue there was whether or not Chin would be liable for fled scene death or serious bodily injury. Okay, because Chin did not strike the pedestrian. It was the intermediary that struck the pedestrian, the taxi. I say then Judge Akoba's opinion rejected that argument and found that you would know that you were involved in an accident involving
Mr. Vincent, the defendant's argument, as I take it, is first of all, Chen involved the prior statute, which included the word
That's correct.
accident, not collision. And also it involved, as you have pointed out, an actual striking between the involved vehicle driven by the defendant and the taxi, which eventually, unfortunately, struck a pedestrian, resulting in her death. So if I could ask you to please address those arguments, I mean, those are distinctions compared to here. And I guess we'll start with the difference with the statute, having the word collision now as opposed to accident.
Okay.
And the significance of that.
So let me address the second one.
Yes.
First, and then the first one. The issue was what, there was collision between Chen and the taxi, but nobody in the taxi suffered bodily injury. So that if the physical contact was the only relevant fact in that situation, then Chen should have been charged with fled scene occupied vehicle, which is, I think, a misdemeanor or petty misdemeanor. So it requires more than just, it includes more than just the vehicle that you're,
Maybe I
it
should,
includes more than just a direct physical collision, definitely.
let me try again. In terms of the difference in the statute, forget the situation in Chen, that's not my question. In terms of the difference in the language of the statute now, we now have the word collision,
Okay.
right? And part of the argument was that makes a big difference because the legislature intended something different with regards to adding that word or replacing the word accident with collision. What is your position on that? And particularly to the question of vagueness that is raised by Mr. Singh.
So as I outlined the legislative history of the statute, of the changes that were made in 2021, right, where they
Yes.
changed the word accident to collision, right?
Yes.
Those were changes that were suggested by NHTSA, and they were suggested not to change the definition of involved in an accident or involved in a collision. They were, I guess, what you would call hortatory changes.
What's your understanding of the purpose of the change in that one word?
The change was to communicate to drivers that accidents aren't random events. They are caused by usually driver error, and they wanted to make it clear to people that whatever you want to call it, accidents or collisions, are preventable. That was the reason for the change, not to change the meaning that that term was given in Shin or the other cases that I cited from other jurisdictions.
So what does that legislative amendment do in terms of impact on this case, in terms of how we should see the arguments here, in terms of either vagueness or whether the complaint or the charges were sufficient? Let's bring it down to this case.
So
what is your argument on that?
With respect to the difference between involved in accident, involved in a crash, there's no difference. There's no operative difference. That's our feeling. Okay, not just our feeling. That's our position. Okay.
So regardless of the fact that there was no alleged contact between Officer Nahulu's vehicle and the other vehicle involved in this matter?
That's correct. So we're saying that involved involves, well, the definition that was given in Chen, which was affected or implicated, and in this case, probably implicated would be the most key word. The defendants in this case were involved in a pursuit.
The defendants are arguing that how can an ordinary person understand what the outer limits are of this involved in a collision?
Well, there are definitely some outer limits, and they're imposed by the plain language of the statute. First of all, it has to be a driver of a vehicle, and it has to be in their capacity as a driver of a vehicle. So I think one of the briefs posited a hypothetical.
If the driver of a vehicle and the passenger are having an argument, and the person in the passenger seat
would not be included.
The driver pushes the person, let's say it's like an open Jeep or something, and pushes the person out.
Oh.
Is that involved in a collision?
Well, so that hasn't appeared in our state, but it has appeared in a number of other states, and which I've cited in my. Well, actually, I did not cite those cases because they were factually a little bit different than my case. But in those cases, a person falling out of a vehicle or being pushed out of a vehicle is an accident or a collision under those statutes.
Sounds like an accident, but doesn't sound like a collision.
I mean, you know, I agree. I agree that, you know, I went around the office asking people what they thought I meant if I said I was involved in a collision. And kind of your first instinct is, oh, you either hit somebody or somebody hit you, okay? But I think that the statutory history, language, the interpretation of it clearly indicates a much broader scope than that. And it's well-established law. Canada's been good law for 30 years. The change to the word collision was not intended by the legislature to change the operative meaning of the statute. If they had intended to do that, they would have gone back to the pre-1971 statute, which specifically requires the driver to have hit another vehicle or person.
I mean, Mr. Singh was bringing it up in sort of at the end of his remarks about, you know, being almost like an actively participating. I mean, I think I would use that as a possible adverb. And it seems like involved in a collision or even the Chen test really doesn't focus on the connection between the driver and the driver's conduct. And it really doesn't say anything about that. And it's almost, you know, this isn't a tort case. It's a criminal case involving a defendant. And I'm wondering what your position is as far as the lack of an anchoring to, one, the active participation by the driver. The driver has to understand what the driver needs to do. That's not really there and involved in a collision. Then I would possibly add to Mr. Singh's suggestion that there's got to be some sort of a temporal sequence. Is you could have a situation where there's conduct that occurs a minute or two ahead of time, and there's no tethering to any sort of sequence or temporal restraint there. So I guess the idea is, shouldn't there be some limiting framework to this broad involved in a collision language?
Well, and I think that there is, because I think you have to. So a pedestrian would not be liable under this law. Somebody who just happened to just be walking along, because you have to be a driver of a vehicle, and also you have to be involved in some way.
So what if, following up on Justice Eden said, you know, what if it's a situation where it's like, you know, kind of like racing, or, you know, sometimes people on the freeway are like given stink eye, and then, you know, like somebody drives off really fast to get away from the other car, and then, you know, 30 seconds later crashes. Was the person that was like harassing that person involved in the collision?
I think it had, yeah, there would be some sort of temporal connection to it. I mean, you couldn't, it couldn't be. I mean, I think that one of the arguments is that except or affected by wouldn't be a good term, because you're affected by every crash that happens in the freeway that blocks traffic, right? So we're not arguing that. What we are arguing is that there's, you know, we think under the facts of this specific case, as applied, the defendants in this case, or at least the lead defendant, Nahulu, understood that he was implicated in this, and implicated in the complaining witness, for want of a better word, going off the road, hitting a fence, and seriously injuring himself.
Well, since you're segueing into the as-applied thing now, and I'll have a question for you that's sort of relates to the defense's, I think, a shift away from an as-applied to facial challenge. But on a facial challenge, this isn't a First Amendment case, is it?
No.
And, you know, it strikes me then when Mr. Singh was asked, well, what's the significant constitutional issue? It's due process. I mean, you could say that on any challenge to a criminal law, you know, to try to tether it and make the defendant get in the game on a facial challenge. So what's your position? Are they just out of the game here on the First Amendment and the lack of a constitutional tether, and they have to do an as applied? And the Attorney General submitted an amicus brief in this case that sort of touches upon
Yes,
that.
and I agree with the Attorney General's,
Okay.
argument that it should be as an applied challenge, not a
The
facial
defendants really don't have the ability to do facial challenges for the most part in the criminal context.
challenge. Prior to trial, that's true, right? So,
Okay.
but I think there are quite a number of facts here. I mean, it's.
But okay, so thank you for clarifying your position there. I wanted to sort of get back to the temporal restrictions, and Justice McKenna was sort of just touching upon it. Let's say there's a person driving very erratically on the H3. They're, crazy, but you have another person who gets cut off. This person gets even more road ragey, let's say, versus the erratic driving. But the erratic driver goes on and is way ahead of him. The road rage person steams up. But that's where we get the temporal and the sequencing. 2 minutes later, before that road rager catches up to the person and almost gets up to him, they crash. Does that first driver, are they involved in a collision?
I think that's a jury issue. So.
But why is it a jury issue when that driver needs to know whether that driver should be stopping to render aid?
Well, it would be a jury issue as to what state of mind he had as to knowing he was involved in the collision.
I guess the question is we're pre-jury. I mean, we're dealing with these issues pre-trial,
and we're
that's
going to
what
have
I'm trying to figure out.
We're going to have to prove a nexus here.
Okay, so would you agree that in crafting something better than Chen, that maybe actively participating, some sort of a temporal proximity, and then really also probably a logical connection or a substantially logical connection
Right.
To the collision, or are those sufficient guardrails?
Yes, and I would welcome the court giving us some guidance as to narrowing down the scope. It's what this court did in Paquin, if you remember. I think you were on the court at that time, but we narrowed the scope of the unlawful possession of confidential personal information statute. Okay, and in fact, you struck down some of the words in the statute, I think. So we're welcome. We think that. We believe that whatever you come up with is going to include the facts of this case.
As far as the facts of this case, you're basically saying the charging language is sufficient and all, but then why did you suggest that, or offer really, to amend the charging document based on what we rule? If it's so good and wonderful.
Well, yeah, we think it's sufficient to inform the defendant of the nature and cause of accusation. But
if it's so sufficient to inform the defendant, why did you propose jury instructions defining what involved in a collision is?
There is no statutory definition of involved in, so there's always a possibility that no matter what we suggest, it's going to be, picked apart later. And I just think that, we thought it was sufficient, as it was charged. I don't know. There was a case that I cited from another state here. Involved constitutionality. This is People v. Burbams. It's one of the cases in my footnote. And this is what they said about it. The interpretation that involved in an accident means connected with that accident in a natural or logical manner is wholly reasonable and delineates anything but an unconstitutionally vague standard. it is inconceivable that a driver is a reasonable man whose actions contribute to an immediately subsequent accident and knew of that causal relationship would conclude otherwise than that he was involved in an accident. And we think the same thing is true of involved in a collision as well.
As far as notice, can you tell us about the bill of particulars, of the 1,900 pages of discovery,
Well,
the jury instructions,
yeah.
and whether the defendant was sufficiently advised as to the nature of the accusation?
Well, there was a lot of discovery given. There's body-worn cameras, computer data, black box information data from the vehicle's accident, I guess, recording device. And there's tons of stuff out there, okay? And I think that the defendants were well aware of what was the underlying conduct that brought them to be charged with this offense. That would indicate that they were involved in an accident, that they knew that they were involved in an accident.
Well, some of the information was potentially that there was contact, there was some kind of collision between the
That's correct.
vehicles, and that was part of what needed to be clarified, right?
And we did clarify that in our bill of particulars, saying
Based
that
on the bill of particulars.
excluding that possibility. We said that we are not going to rely on that theory.
Mr. Singh's argument is still that your bill of particulars is woefully short.
Well, you know, it was, I think, the specification that they wanted to hear. They wanted to hear that we're not going to charge it on that theory that there was a collision. And we did inform them that we were not
And the
gonna
theory
try it on
going
that
forward
basis.
is that there was no collision, in fact.
The accident reconstruction people seem to think that there was no collision.
Well, that's what your bill of particulars says,
Yes. Mhm.
You use the word contact in the bill of particulars, not collision, because otherwise there's no collision.
Yeah.
The collision is
Right. So two bodies meeting, I guess.
the other vehicle's collision.
Oh yeah, I mean, yeah. I guess there was no collision, and then there was the collision of the
You
vehicle.
use the word contact in the bill of particulars, not collision.
Yeah, that's correct. Okay, I believe that's true.
That
Yeah.
you're not relying on the theory that there was contact.
That's correct. Mhm. That there was contact between
The vehicles.
the defendant's vehicle, yeah,
Right.
and then the CW's vehicle.
Well, they're complaining about, well, you didn't really tell us more, but I mean, your theory is that it's the pursuit, right?
Yes.
That's how Nahulu was involved. So it really doesn't matter. I think that would be your position.
And the cases I cited generally fall into two groups. One is where a defendant forces another driver to take evasive action, usually at an intersection, right? And the victim ends up in an attempt to avoid the defendant's vehicle, ends up hitting another vehicle or another object and a lot of times dying, right? The other cases deal with the race or competition scenario, where there's two people actively, there's meeting the mind. There's an agreement as that we're going to race, and the other car involved in the situation strikes somebody, a victim, a pedestrian or a car, and both of those are pretty clear. We think they're pretty. I think the person that common understanding.
We could come up with so many hypotheticals. You folks did actually repeatedly in those briefs. But
well, I didn't use the hypotheticals. I only use true cases.
Let's talk about a drag race situation like you were just describing. One person, let's say, chickens out and doesn't go, although they were revving their engine, and he stops here, and this guy, way down the road, goes off the crash.
So my position is this. I don't know if you've seen the movie Rebel Without a Cause with James Dean, right?
I was thinking more American Graffiti and Fast and the Furious ones, but
similar things may have happened there. But I just remember the scene from Rebel Without a Cause. They're having a chickie run, right? They're driving towards a cliff. One of the drivers, the last driver to bail out, right, is the chickie, right, the person who's chicken, right? No, the first person they bail out is the chickie, okay? The person who doesn't is the winner, right? So James Dean, the character played by James Dean, is going down toward the cliff, and he sees that the person next to him is not bailing out, right? And it turns out that the competitor got his cuff caught in the door handle and is not able to get out, and the car ends up going over the cliff and crashing and killing everybody. We think that is involved in a collision. So, yeah, we would stretch it as far as that.
Would you stretch it as far as James Dean himself chickening out and the other guy going over the cliff?
James Dean did chicken out.
No, I'm saying James Dean didn't even start his car. When they said go, James Dean just stayed there.
Okay, yeah. Yeah, I guess that's a gray area. I wouldn't. Maybe I wouldn't apply it in that situation.
That just highlights.
Yeah.
We can come up with so many darn hypotheticals on both sides that really you're not going to encapture whatever standard is used in this type of charge. Mm-hmm. There's always going to be gaps, and I think what we need to try to do is come up with a framework that plugs and recognizes the defendant's rights and tries to plug all those gaps. And I'm hearing what you said earlier on my suggestion that those might do that. Is that right?
That's correct. Yeah. Mm-hmm. That we were just asking that you give as much, give meaning to the statute as perhaps the legislature would have meant to have written it if they had been presented with this particular factual situation or others like it.
Anything else?
Nope, that's it. Thank you.
Thank you, Mr. Vincent. Rebuttal, Mr. Singh.
Thank you. I'd like to start with something Mr. Vincent said. He said he took an informal straw poll at his office. He went and asked, what does involved in a collision mean? And he was told, it means you hit somebody or somebody hit you. And that's the fundamental problem here. That's why I believe a facial challenge is appropriate here, is because that is not how these statutes can be applied. It fundamentally differs from our common understanding. When I say I was involved in a collision, it means I hit somebody or somebody hit me. I agree with him and the prosecutor's office on that point 100%. But that is
so then it's not, because a facial challenge is striking down the statute entirely.
Yes.
You're conceding that it applies when two cars collide. So this is not a facial challenge. You're saying it's vague, and it's vague as applied to our situation where the Bill of Particulars says we're not relying on a theory of contact between the vehicles. That's an as applied challenge.
I understand. And what I'm attempting to argue is that a motorist cannot determine their obligations under the current statute and the current definitions that are listed under the statute. And that, I think, is a facial challenge. If I have the terminology wrong, then I've got it wrong. But when I look at this, that's the fundamental problem I have, is that the common understanding of that phrase is completely different than the way this statute can be applied. And it creates this situation of arbitrary enforcement. And it gives too much discretion to the prosecutor's office to decide where and what.
Mr. Singh?
Yes.
Are you asking that this court look at it as applied to or just facially?
I'm going to ask for both. The only thing we really didn't specifically do here is argue over breadth. And that was the front-end decision by me on trying to determine exactly what I felt the problem with the statute was. And the problem with the statute, as I see it, is a vagueness as opposed to what everybody thinks this phrase means, as opposed to how the statute can be applied and how it has been applied here. So if I'm making both arguments, then I make both arguments. I'd like to also briefly touch on this idea of accident to collision, because I think it's an important idea, because I think what happened here, intentionally or not, is they narrowed this statute. Accident has a connotation of undesired, unexpected, causation comes into a play. And Chen tells us causation's not the test. But that's really sort of a broader idea of accident. It involves more things. Collision describes simple contact. And when a motorist is trying to look at this and look at these terms, the idea that focusing on the actual collision when everybody thinks that that means my car, that's the fundamental problem I tried to raise here. And I stress that it's hard, and you have to ask yourself, how are our motorists to know? Because it's not just a proximity problem. I agree it's a temporal problem as well. And I think you also need an adverb in there to tell you how close, marginally, substantially. You know, we have all kinds of different terms that we use to try to do that. Common nucleus of operative fact, all those kinds of terms to try to limit and narrow so people can know and people can describe. And that's what I think our fundamental problem is. Thank you for listening.
Thank you very much to counsel. E kau pa ona ka aha o kolokolo ina mea pili I keia hihia. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolokolo ki ike hanohano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.